Today we're diving into the intricate world of asset protection. Why, in an imperfect justice system, it's not just a strategy, but a necessity for many. Imagine you're in a legal battle. You believe in justice and that the truth will prevail. But here's the harsh reality. Often the winner isn't the one with the right on their side, but often the one who can afford the best legal representation. And it's an open secret that the outcome of lawsuits can heavily depend on who has deeper pockets. This isn't a failure of morality, but a systemic flaw where the resources outweigh the righteousness. The uneven scales of justice. Now here's some more examples where lawmakers in the United States, many of whom have legal backgrounds themselves, have occasionally passed legislation that could be seen as benefiting the legal profession. Here are a few examples that have been observed over the years. Tort reform legislation, where tort reform is often promoted as a way to prevent frivolous lawsuits and reduce insurance costs. Critics argue that certain tort reform measures may actually benefit lawyers by creating complex rules and exemptions that make litigation more lucrative for attorneys experienced in navigating these complexities. Intellectual property laws has significantly increased the demand for specialized legal expertise benefiting lawyers working in these areas. Bankruptcy reform changes in 2005 made it more difficult for individuals to file bankruptcy under Chapter 7, requiring them to seek legal counsel to navigate more stringent requirements. Complex tax legislation. The U.S. tax code is notoriously complex and undergoes frequent changes which benefit tax lawyers and accountants who are needed to interpret and apply these laws. Securities regulations, including the Sarbanes-Oxley Act and the Dodd-Frank Wall Street Reform and the Consumer Protection Act of 2010. These laws made things so complex with harsh punishments that it benefits lawyers specializing in corporate and securities laws. The Class Action Fairness Act of 2005 made it easier for class action lawsuits to be moved into federal courts. Privacy and data protection laws require specialized legal knowledge to ensure compliance, benefiting tech and privacy lawyers. Healthcare legislation, including the Affordable Care Act and HIPAA regulations, have made things so difficult for doctors that they have to hire attorneys just to navigate the waters. These examples show how legislation can indirectly benefit the legal profession by creating demand for legal services. However, it is also important to note that the stated intention behind many of these laws is to address real issues within society, the economy, or the legal system, even if one of those byproducts is increased work for the lawyers. The offshore trust loophole. Now here's where it gets even more interesting. The offshore trusts offer a loophole. Despite the domestic laws, money placed into an offshore trust is often beyond the reach of U.S. civil rulings, including those for fraudulent transfer, now called a voidable transaction. Now, this isn't to advocate for evading responsibilities or hiding money unethically. Instead, it's a critical look at how the wealthy and informed can navigate the laws to their benefit, often legally, while others remain vulnerable. Asset protection, in essence, isn't about skirting justice. It's about navigating an imperfect system where many times judges get it wrong, where the playing field has been tilted by lawyers in favor of lawyers who want to take advantage of the system that they've designed to make it easier to transfer your wealth from your pocket to theirs. Plus, the ideal justice for all system struggles against the reality of justice for those who can afford it. So understanding these mechanisms is crucial, not just for personal asset protection, but for advocating a more equitable legal system where justice isn't a commodity, but a guaranteed right for every individual.